Hello, I'm Professor Bustillo-Booth. Thank you for joining me in this learning session. Today I'll cover major aspects of the Age Discrimination in Employment Act. Let's go ahead and get started. In this session, we'll discuss historical information that puts into context the value of the ADEA. We'll also quickly distinguish the perception and reality of older workers' contribution in the workplace, as well as understand what the law actually allows around age discrimination, and quickly discuss management considerations. Before we dive into the law, let's take a look at some historical information that will help us understand the value of the ADEA. One of which is the U.S. life expectancy. And you can see in this graph, from 1880 to 2015, there has been a significant improvement in the average life expectancy for those in the U.S. Beginning in 1880 here, you can see that their life expectancy was on average about 40 years. And as quality of life improved, technology improved, and there were advances in medicine, people slowly advanced in their life expectancy. And around 1967, the ADEA was passed, in part to recognize that people remain productive and were vital members of the workforce well after they were 40 years old, and they needed some protection. And you can see here that the life expectancy continues to increase into the modern era. And we'll suspect with advances in medicine that people will also tend to live longer as well as work longer. And in this graph, we can see the aging of the U.S. workforce. And workforce is defined as people who are readily engaged and available to work, right? So that would be the workforce. Those who are in retirement years or those who are not able to work are not part of this calculation. And you can see here on the y-axis, these are the number in thousands. And so we would just add 3 zeros at the end, and then we would have 20 million, right? And 40 million and so on. And then on the x-axis, you can see that these are in 20-year increments. And that's generally because generations are seen as within 2 decades of each other. And you can see that in 1950, the older workforce population did not make up a large portion of the workforce, right? So the 65 and 55-year and older were relatively smaller proportion of the workforce. And as the U.S. expectancy got better, and of course there are more people, you can see that there is a significant shift in what makes up the U.S. workforce. So you can see here in 2010, those that are under 34 years of age make up a larger portion of, relative to historic terms, of the U.S. workforce. So this is really a workforce pool here, and where the talent is and where employers are going to have to look to in order to serve its productivity needs. So that's really important to understand. And you can see here from 2010, 2030, and 2050, there is a very large jump of the number of people who are 65 years and older who will still be in the workforce, right? And these are generally those who are going to be of the baby boomers, as well as the baby boomers' children. That's what this group is going to be, and they're going to be productive individuals looking for means to support themselves economically and to continue to pursue the things that they're interested in. So this is a viable workforce. Now, there are societal notions and stereotypes around older workers that persist, that say something to the effect of that older workers are somehow less innovative, less productive, and less able to contribute to our high-paced industries. And what studies have shown repeatedly is that older workers are generally better performers. And that's because they tend to be more experienced and skilled. They've gone through a lot of changes and have learned to adapt, and therefore make less mistakes. They typically are very dedicated and reliable and highly accountable. They tend to be punctual and have less absenteeism issues, and they tend to be team players. They also tend to be organized and efficient, and in many ways more productive because of that efficiency. They also tend to be confident. Years of working in the field have brought about confidence because they're also experienced and skilled, and so they become able to represent their company better. They also tend to have better communication skills and therefore bring better interpersonal skills in the workplace that then build teams and help projects move forward because they're able to work with different people and figure things out. Now, of course, it's important to always remember that generalizations do not apply to all workers. Just as all old workers are not necessarily experienced, dedicated, punctual, organized, confident, or have better communication skills, there are also younger workers who are not necessarily getting the job every time they compete with an older worker, or that they have lower unemployment rates than older workers, or that they can easily find jobs because older workers are retiring all the time. In fact, in general, older workers are sticking around, working longer for not only economic reasons, but for self-vitality reasons, because they like the work, because they want to continue to be productive. From a managerial standpoint, it's really important to really consider the professional, the individual, the worker, based on their ability, and not to really fall into notions of stereotypes and make decisions around stereotypes or perceptions. When Congress crafted the ADEA, and when it continues to revisit the value of this law, it recognized and continues to recognize the socioeconomic impacts on older workers as industries change. And there's a need for increasing productivity through technological advances, and that older workers can find themselves very disadvantaged in their efforts to retain employment and also to regain employment when they are displaced from their jobs. So when automation comes online, for example, or jobs are outsourced, and or in their efforts to get retrained, right? It may take a long time, or the retraining itself is costly and they may not have access to that retraining, or that there's a lag time in the industry for the retraining. They might find it very difficult to re-enter the workforce. So Congress recognized that. And Congress also recognizes that there became a common practice of putting arbitrary age limits regardless of an individual's ability to do the job. And so they wanted to address that. Congress also recognized that long-term unemployment tended to be higher among older workers, and that this resulted in the deterioration of skill and morale, and that these had societal costs to them. And so they would increase social services costs to try to help folks who are now in long-term unemployment. Ultimately, Congress recognized that the arbitrary discrimination in employment because of age had an immense impact on our economy, on our mixed capitalistic economy, because it appeared to be occurring across many industries. And the resulting impact of that is that there were significant portions of the population that were finding themselves unable to participate in our economic infrastructure because they didn't have the job. They didn't have the economic agency to become consumers in our mixed capital society, which is really what is meant there when we talk about the free flow of goods in commerce. And then therefore, we're not contributing members in the vitality and productivity of the nation. And so Congress decided that their groups, particularly those age 40 and above, needed protection. Now, what does the federal law actually say? The Age Discrimination in Employment Act that was passed in 1967 basically prohibits discrimination in employment on the basis of age. And it applies to individuals who are at least 40 years old. And it does not cover individuals who are under 40 years old. And the enforcing agency here is the Equal Employment Opportunity Commission, or the EEOC, which is also the agency that enforces Title VII of the Civil Rights Act of 1964. Now, the ADEA does allow for some employer defenses One is around the bona fide occupational qualification, otherwise known as the BFOQ. And it basically allows employers to have a maximum age limitation if the age is reasonably necessary to the normal operation of that particular business. And an example of this is that of airline pilots. So airlines are allowed to have a maximum age in order to safely fly those planes. And any employer, whether it's an airline or otherwise, would need to prove that age is a BFOQ for a particular position. And it's important to note here that the BFOQ has a very narrow in scope, so it really does have to be a business necessity. Another reasonable defense under the ADEA is something called the reasonable factor other than age. Now, this is a very difficult notion to apply at the employment setting. But basically what it is that the employment practice, whatever the practice might be, has to be both reasonably designed to further or achieve a legitimate business purpose. That's the purpose of the business. And that it has to be administered in a way that reasonably achieves that purpose. And it has to be based on the particular facts and circumstances of that particular situation. And the bottom line question for the court really is the non-age factor reasonable? That's a question that they ask, and they basically, this is generally looked in on cases that are around disparate impact. So those are policies that would seem neutral on the face of it, but may have disproportionate impact on certain groups. Now, let's take a look at a couple of scenarios to help illustrate how what the law actually allows under the ADEA. Now, these scenarios are not comprehensive, and they will not be able to cover all aspects of what the law allows, but it'll give you a sense of what would be considered illegal or legal. All right, so in this scenario, a company has many senior business workers, and their salaries are now about 300% of entry-level workers. So in an effort to cut costs, the company is considering hiring new MBA graduates at a competitive salary and letting go of several of its senior staff. What if the older employees, however, agree to take a pay cut? Should the company proceed with the hires? Now, this is one of those really tricky questions, and it could fall under the RFOA, the reasonable factor other than age, if the firm makes this decision on a purely economic basis. So it's a factor other than age. However, the courts have said that where the salary is used in place for age, so the salary is a proxy for age, the salary may not be used to determine this particular employment decision. Otherwise, it would be considered illegal. Now, this is again, a very extremely difficult issue, and it's important that the company, if it proceeds to go with the hires, it can make the case that it was a purely economic basis. But in this case, if the older workers agree to take a pay cut and they proceed anyway, this would likely be seen as illegal. Now, let's consider another scenario. In this case, a manager interviewed 2 applicants for a strenuous position, and it would require quite a bit of training. One of the applicants is a 55-year-old, and the other is a 30-year-old. Now, the 55-year-old is more qualified, and far more qualified than the 30-year-old. But the manager is concerned that over time, this applicant may no longer be able to do the job. What does the manager do? Does the manager hire the applicant anyway? Now, the ADEA would look at this particular scenario and say, is the individual qualified at the time of the hire? So in this case, the manager can't be thinking 5 years from now, 10 years from now, however many years from now, and saying, you know, I really don't know if this 55-year-old will be able to do the job then. That would be illegal. In this scenario, the 55-year-old is qualified to do the job, and that basically is all that matters. And so in this case, the manager should hire the applicant because they are qualified for the job. Of course, there are many other age-related scenarios that would involve employment decisions around benefits and retirement packages and retirement in general. And the best thing for a manager to really consider is that to judge the employee based on the work-related criteria, because and to be very careful around matters that involve reduction in force, or otherwise called as a RIF, because those are really prone to age discrimination claims. So therefore to make sure decisions there are based purely on economic basis. Now, there are other management tips that are covered by your book, and I invite you to look and read them very carefully. And among them is to make sure that you review all company materials for age bias. That's just a general good practice, no matter what, right? Make sure that people are trained to consider people, the workers, on relevant work-related criteria and not on age. It's just a safe bet to go down that route. All right, that brings us to the end of this quick overview on the ADEA. I hope you got some major concepts there, and that you will visit your book to read more closely on the many deeper elements of the law. Should you need my help, please reach out to me. My contact information is in the syllabus, and reach out to me via email or by phone, as well as visit me in my office. I am always happy to help. Thank you so much.